want to now turn it over to one of our attorneys, a wonderful attorney, so well knowledge. I call her the walking encyclopedia. She's the managing attorney of our Tampa office location in the Tampa Bay area. That's something else a lot of people confuse. Tampa is in Tampa Bay. Tampa Bay is not the one, it is encompassing many different areas. Kerstin Henze from our Tampa office location. Kerstin, please take it away.
Thanks, Jeff. Hello, everyone. Good afternoon. Thanks for joining us at 2 o'clock on this fine Thursday. Like Jeff mentioned, I'm Kerstin Henze. I'm one of the partners and managing attorney for our West Coast office, which is located here in sunny Tampa. So today we're going to be talking about updating your governing documents. And let me try to get the slides on. Okay.
Perfect.
See that? Okay, very good.
We see it.
Okay, very good. So first thing, hierarchy of the governing documents. Okay, there are a number of documents that comprise your governing documents. Okay, and both condominiums, co-ops, and HOAs have same set, similar. Okay, so for the condominium, you have your declaration of condominium, your articles of incorporation, your bylaws, and for homeowner associations, you have a document that's called the Declaration of Covenants and Restrictions, which is basically the equivalent of the Declaration of Condominium for condos. And then HOAs also have articles of incorporation and bylaws. Okay. Those three sets of documents comprise the governing documents. Now, your association might also have rules and regulations and possibly even architectural guidelines or maintenance standards and policies. Now, those rules and policies are not part of your governing documents. They are exactly what they are. They are just rules and policies, okay, that are basically, they supplement your declaration. Now, in terms of hierarchy, your declaration of condominium and your declaration of covenants is going to be your supreme document. Now, that is the document that basically it establishes a contract between the association and the owners that buy into the community. And so it's the document that's going to contain the bulk of the use restrictions and the covenants, what you can, what you cannot do, the maintenance obligations, any architectural control requirements, conditions, and so forth. Okay. Now, your articles of incorporation and your bylaws, these are the documents that essentially set out the corporate structure of the association. As you're all aware, the association is a corporation that's not for profit. Okay. And so the articles of incorporation is the document that was necessary to establish the entity. Okay. And in the state of Florida, the articles of incorporation are filed with the Division of Corporation in Tallahassee. Okay. And so the bylaws is basically an extension of your articles of incorporation. So they will identify who the members are, who comprises the board of directors, how many directors are required to sit on the board, how are vacancies filled, resignation, elections, that type of thing. Now, it's important to note that when you're amending, and we'll talk about amending in the following slides, but particularly when you amend your bylaws, you want to make sure that there is no conflict between the bylaws and the articles. So your articles, for example, a good example would be a provision in the articles that might say, the board of directors shall consist of no more than 5 directors. And then you might have a similar provision in the bylaws. So let's say the board now wants to amend the bylaws to change the number of directors that are required to sit on the board of directors. Well, when you make that change to the bylaws, just make sure to take a look at the articles of incorporation to make sure that there's no conflict. So it's quite possible that you may also need an amendment to your articles of incorporation on the same provision. Okay, so just do a check of your articles when you amend your bylaws.
Good
Okay,
advice.
moving on. So the amendment process. So first, when you want to amend any provision in any of the governing documents, okay, what both the Condo Act and Chapter 720 provide is that you have to type up your amendment. Okay, if you are just amending a specific section, you'll have to type up the language in the section that you want amended. If you are amending your entire declaration or your entire bylaws, then the statutes require that you type up the entire bylaws or the entire declaration, whatever it is you're amending. And then the statutes also require that you have to annotate the changes by underlining the language that you are adding and then striking through language that you are deleting. Okay, so that when you present these amendments to the membership can see what the changes are. Now, the statute also says that if the changes are so substantial that is basically going to hinder the process of the owners reviewing these amendments, then in lieu of underlining and striking through the original language of the document, you can basically make your changes without the underlines and strike throughs, and then put at the top of your amendment the verbiage that's set forth in the statute, which is, substantial rewarding. Please see the governing documents for the original text. Okay, so that's an option. Now, whether you want to do that on substantial changes to the documents, for example, if you are doing a complete rewrite of your declaration, whether you want to do the changes without underlining and striking through and then adding that provision at the top, that becomes a business decision.
Yeah.
Many owners would prefer to see the actual changes. So you kind of have to consider how best to present the changes to the membership. Okay. Now, the amendments can be presented to the owners either for approval at a membership meeting, and this could be your annual meeting or a special membership meeting, or amendments can be presented to the owners by the written consent process, and that's in lieu of having a meeting. Okay, so if you're going to present the amendments at a meeting, you would have your notice with an agenda item, and you will include as part of the agenda, consideration of amendments to and identify what the amendment would be. You're not going to include the language of the amendment, just identifying, consideration of amendment to the declaration or to section, 5.6 of the bylaws. Okay. And then we'll talk about in a minute, proxy. So you will mail out the notice of your membership meeting with a limited proxy and the proposed amendments for the membership to consider. Okay. Now you'll have to look in your bylaws to see when you must mail the notice along with a copy of the amendments. It might be that, your bylaws might provide that, any notice just needs to be mailed to the owners 14 days prior. You might have, depending on which document you're amending, you might have specific language to say that a notice of a meeting at which you're going to be amending that particular document has to be mailed out within a certain time frame. So you want to look for specific language on when you need to mail out the notice to the membership at which they're going to be voting at that meeting. Okay. And then in lieu of, you have the alternative of presenting the amendments through a written consent process. Now, the written consent process is specifically set forth in Chapter 617 of the Florida statutes. And that is the statute that governs non-for-profit corporations. So associations are not-for-profit corporations. So depending on whether you're a condo or an HOA, you will be governed by Chapter 617 of the Florida statute, as well as 718 or 720. Okay, so 617 sets forth the process. And essentially, with the written consent process, you're going to be mailing out the amendment with a memorandum that's going to contain at the bottom of that memo signature line for the owner to sign and consent to the amendment. So you'll say, here are the enclosed amendments to, section 6.5 of the declaration. This is what we're trying to amend. This is what we're trying to achieve. If you are in agreement, please consent and return this consent form to the association within a certain time frame. Now, the statute says that you have 90 days from the date of the first executed consent form to get the necessary consent forms to get the amendment approved. So if you need a vote of the majority of your membership, then that's how many consent forms you'll need to receive. If an owner does not consent and does not return a consent form, then that's basically a no vote. So what you're counting is affirmative consent forms. Okay. Now, the authority to go through the consent process should be in your bylaws. So check your bylaws, okay? Now, proxy voting, which is here the second bullet point. Proxy voting is going to be done in conjunction with a meeting. So like I mentioned, a limited proxy is going to be mailed out with the notice and the proposed amendments to the owners. Those that can't come to the meeting can simply indicate how they want to vote on the limited proxy and then return the proxy to the association prior to the meeting.
Yeah.
At the meeting, you can also have ballots, okay, so that owners who are present and wish to vote in person as opposed to a proxy, they can just fill out a ballot, okay, and indicate, yes or no vote for the specific proposal. Now, with membership meetings and proxies, the proxies are good for 90 days from the date of the original meeting. So let's just say you are looking to hold a meeting February 1st. You've mailed out your notices, your limited proxies, your amendments. February 1st comes, you count the limited proxies and the ballots, and you just don't have enough to get the amendment passed. Okay, well, that proxy is still good for 90 days from February 1st. Okay, so if you recess and reconvene the meeting, which is an option as opposed to adjourning the meeting, okay, and you can do that as many times as you want within the 90-day time frame, then you can potentially knock on doors or send out email blasts, let the neighbors know, hey, we don't have enough votes yet to pass this amendment. This amendment is important for the community. Please return your limited proxy by this date.
Yeah.
Okay. And you just continue to tally the proxies. Okay. Now, to properly recess and reconvene a membership meeting, essentially, you'll need a vote of the majority of those owners who are present at the meeting. Okay. So if you just have 10 owners present at the meeting, then as long as you make a motion and then a majority of those that are present vote to recess and reconvene the meeting for another date within that 90-day window, then you can do that. Make sure that you also announce at that meeting the next meeting date. So, you can make a motion, I make a motion to recess this meeting because we haven't received enough proxies on this amendment. So let's make a motion, let's reconvene this meeting for March 1st. Okay, and as long as you get the vote, then the next meeting date will be March 1st. Okay, and you can collect the proxies through that time. March 1st comes around, you'll go ahead and you count your limited proxies and ballots, and if you still don't have enough votes for the amendment, then you go through the same process up to the 90th day.
Right.
Okay?
This is not starting a new 90 days. We need to make sure that's clear for everybody.
Yes, the 90-day is still as of that initial February 1st meeting.
Right.
Okay. So once you receive the necessary votes, or let's just say you've reconvened the meeting, several times, and you're already at that 90th deadline, and you now still don't have the necessary votes, well, at that point, that's it. Okay. You'll need to adjourn the meeting. So you'll make a motion to adjourn the meeting a second, and then that meeting is over. So essentially you didn't get the votes, and your option is basically to reintroduce the amendment again, if that's what the board chooses to do. Okay. Now, in terms of distribution to the members, the notice of the meeting with the amendment and the limited proxy, or if you're doing that by written consent, the written consent and the amendments can be distributed to the owners either by mail, hand delivery, or through electronic transmission, which is typically email, to those owners who have consented to receiving official notices by email. Okay, so you want to make sure that you have received a written consent from the owners consenting to receiving official notices from the association by email. Then those owners can get the the consent form or the notice of the meeting and the amendments by email. Now, vote tally. You got to look at the governing documents that you're trying to amend to see what the voting percentage of the membership that you need to pass these amendments. Okay, so if you're amending the bylaws, you got to look to the bylaws. If you're amending the declaration, you got to look to the declaration. If you're amending the articles, you got to look to the articles. Okay, and more likely than not, those documents will tell you what the percentage vote you need. Now, if they are silent, then for condominiums, the statute says that if your documents are silent on the voting percentage, you need to amend the declaration, then you'll need to get a vote of 2/3 of the voting interest. And the same vote applies to homeowner associations. So if your documents are silent, then the statute says you need a vote of 2/3 of the voting interest to amend. Okay. Now, if you have a high voting percentage and 2/3 of the membership of the voting interest, sometimes, it could be high for your community. Or let's say you have a requirement for to get the approval of 75% of the membership. Then one thing you might consider is before you present a substantive amendment to the membership for approval, you might want to present to the owners an amendment to reduce that voting percentage. So you might want to consider reducing a percentage to, a majority of the voting interest. Some communities have reduced the voting percentage to a majority of quorum or a different percentage of quorum. Okay, so that would mean, for example, if we have a community of 100 units or parcels, and your quorum, let's say for condominium, you have 100 units and your quorum is 50%. Okay, so quorum is the minimum number of owners that need to be present at the meeting in order for the meeting to even proceed. So 50% would be, or a majority would be 50% plus 1. So let's say you have 51 owners present either in person or by proxy. And you have a voting requirement that says majority of those owners present at the meeting at which a quorum is present. So that means the voting percentage that you need to get the amendment passed would be a majority of the 51 owners that are present, assuming that's the minimum number that's there. If you get quorum and let's say 75 owners show up, then a majority of quorum would be the majority of the 75 that are present. Okay. For some communities, that works. Okay. So you have a better feel for your community. You know what's best. These are just some of the options that you may want to consider in lowering the voting percentage to amend your documents. Okay. Now, material amendments. There are some amendments. Oops, I think I went too fast. There we go. Some amendments might be considered material. Okay. And those typically are amendments that, for example, change the voting percentage of the membership or the percentage in the common expenses that owners have to pay to the community or percentage of the common elements owned by owners. Typically, amendments to these provisions would be considered material, and under both 720 and 718, they would require the vote of 100% of the owners plus mortgagees. And in fact, you might even have specific language to that effect in the actual declaration or bylaws. Okay, so kind of parrot what the statute already provides. Those are amendments that typically communities do not undertake just by the fact that it's a very high percentage of votes that you'll need to obtain. So those amendments typically never get done. All right, leasing and rentals. We'll talk about, you know, amendments to authorize purchases and leasing, but I wanted to point out two sections specifically in the statute that address leasing. Now, neither 720 nor 718 really, speak to, substantive use restrictions. Okay. For example, whether you can park a commercial vehicle in your community, whether, whether you can do certain alterations, whether you can have guest occupant, these types of restrictions are typically very document specific and would be in the declaration, okay? But the statute does speak as to leases. And for the condominium statute, what it says, and I believe this was an amendment back in, I think 2004. So what the statute says is that if you're going to amend your declaration to either prohibit owners from renting their units, or if the amendment alters the term of the lease, for example, you are allowing owners to rent, for less than 3 months, and now you want to put a restriction that says you can't rent for less than 12 months. Okay, so you're altering the lease term. Or if you're going to put a limit on the number of times that you can rent a unit in a calendar year, then the statute says those types of amendments will only be effective against those owners who vote in favor of the amendment and those owners that take title after the amendment becomes effective. Okay, so an amendment becomes effective when it's recorded in the public records. Okay, so essentially you would have to keep a tally as to which owners voted in favor and which owners either didn't vote or rejected the amendment. Okay, and that's going to become important at the time of enforcement. Okay, now 720 for homeowners association, there was a change in the statute that took effect in 2021, which essentially mimicked the language of the condominium statute. So whereas before, homeowner associations could amend their declaration to prohibit leasing or limit the term or the number of times you can lease, now you are basically kind of stuck with this language from the condominium statute. Okay. So only those amendments would only apply to owners that vote in favor of it and those that take title after the effective date of the amendment. The one distinction of the HOA statute is that it does allow associations to amend your declaration to at least prohibit leases for less than 6 months or more than 3 times in a year. So if you are considering an amendment to prohibit leasing less than 6 months or more than 3 times in a year, then the statute says that amendment would be effective against everyone. Okay, so just be cognizant of the statutory provisions when it comes to amending your lease restrictions. All right, suspension of voting rights. So one mechanism to assist associations in getting an amendment passed is to possibly suspend voting rights of owners who are delinquent. Okay, so for condominium association, if you have an owner who is delinquent on any monetary obligation of the association, whether it's assessment, late fees, interest, attorney's fees, or even fines, okay, as long as the owner has been delinquent for more than 90 days and the monetary obligation to the association that's delinquent is at least $1,000, then you can suspend voting rights. Okay, and for homeowner associations, somewhat of a similar provision. If you have a homeowner who is delinquent more than 90 days on any monetary obligation to the association, you can suspend their voting rights. Okay. Now, suspension of voting rights is authorized in the statute. There has been some case law, however, to suggest that really that authority should be in your governing documents, declaration, although typically you see it in the bylaws. So case law says it should be in the bylaws in order for it to be effective. So, check your bylaws and get with counsel. And an abundance of caution, you might want to consider an amendment to your bylaws to give you that specific authority so that you don't have a potential successful legal challenge in light of this recent case law that came out. Okay. But assuming you have the authority and the owner, qualifies for this suspension of voting rights due to the delinquency, the suspension is done at a board meeting by a board with just 48-hour notice. Okay. Post-it notice. This is not like a suspension of use restrictions or a finding process that requires the 14-day notice and then the hearing in front of a committee. No, this is just a board action at a board meeting with a 48-hour prior notice. And if the suspension is properly undertaken, then essentially that unit or parcel is just not counted towards the quorum requirement or the requirement needed to amend your governing document. So if you have a community of 100 units, 100 parcels, and you properly suspend the voting rights of say 10 owners, then the voting requirement would be based on the 90 owners, and then the quorum requirement would be based on the 90 owners, not the 100. Okay. And then lastly, we have mortgagee approval. So we discussed here in the material amendments that there could be amendments to your governing documents that require mortgagee consent. That's typically to amend voting rights or percentages that owners pay in assessments or percentage of common elements owned by the owners. You might also have a provision in your governing documents, typically found in the declaration, but your bylaws could have it as well, that says basically any amendment that could, prejudice or impair the rights of mortgagees requires the approval of mortgagees. Now, that's a relatively broad provision, and so quite possibly, any change to the governing documents could potentially impair the rights of mortgagees, right? So, for example, if you were to amend your documents to now require tenants to go through the approval process, and you have a mortgage company that just foreclosed and took title and wants to lease a unit, well, now that mortgage company, that lender is subject to having their tenant screened by the community. So potentially, the mortgagee can make the argument that the amendment affects their rights, right? And that the association needed to get the approval of the mortgagee. Okay, so check the language. If you have that language, then both 718 and 720 does outline a statutory process that you need to go through to get mortgagee consent. Okay, typically the process entails you having to do a title search, confirm which units or parcels have first mortgages, and then confirming with those lenders whether they are in fact confirming with the owners whether in fact the mortgage companies that were reflected on the title search are the lenders to whom they pay their mortgage, and if so, then the statute requires you to notify those mortgagees, let them know, hey, we're amending the document, this is the amendment. And it's basically a negative notice process. You let them know that if you don't hear from the mortgagee within 60 days from the date of the letter, then their consent is presumed, and you can go ahead and record the amendment in the public records. I can tell you I have done this plenty of times, and I've rarely received any objection from a lender. Okay. Now, whether they ignore it or, don't really have an objection, who knows? But the bottom line is that uh, rarely have I've received in one instance an objection from a mortgagee, which was resolved. But other than that, unlikely that a mortgagee will even respond to your letter. Now, if you decide as a board, you make the business decision not to involve mortgagees in your approval process, not to get their consent, then obviously there's a risk of potential legal challenge that when you come to enforce an amendment against the mortgagee can raise this as a potential defense and say, hey, you didn't get my approval, which was required, and now this amendment does not apply to me. Okay. Now, if you see over here, I indicated that the statute of limitations to challenge a recorded amendment is 5 years. Okay, so if you don't get mortgagee consent, then you have a risk of legal challenge, for 5 years from the date of the recording of the amendment. Okay. All right, that was actually a very long slide. Moving on. All right, so let's kind of go through some misconceptions, and we're going to talk about several amendments, the more common ones. You want to look at this language in your governing documents to see if it needs amendment. Okay, but these are the more common provisions that you would want to look at and possibly amend. You might have, way more than that. Okay, but for purposes of this webinar, we'll just focus on these. So, what provisions are illegal? Well, I mean, essentially, any provision that would run afoul of fair housing laws, right, or are discriminatory, those would be illegal, right, and subject the association to a discrimination complaint. So you want to make sure that you don't amend your documents that have discriminatory language or can be interpreted as, discrimination. So, for example, if you are a community that is not a housing for older persons, you're not a 55 and older community, and you have, express clear restriction that says, children under 18 are not allowed, well, that's on its face discriminatory.
Hmm.
Okay, so you want to make sure you amend it, even if you don't enforce it. By virtue of just having that provision in your documents, you're already exposing yourself. Okay.
Yeah.
Now, what provisions are holding you back or costing you money? That's a discussion that you'll want to have internally with your board, possibly your even your legal counsel. Is the percentage for amending your documents too high? Okay, and so possibly creating a hardship in amending certain language that would benefit the association. Well, you want to consider, like we discussed, reducing that voting percentage. Or, for example, do your governing documents lack language that give you the ability to assess an owner for expenses incurred by the association on behalf of the owner? For example, if the owner was negligent and damaged common elements, and then you had to expend money to repair, and now you're stuck with this $5,000 bill. Well, you can always demand it from the owner, right? And there's always an option of doing a small claims, case to pursue it. But more often than not, you're not going to file a lawsuit to recover $5,000. Well, you might want to have language in your governing documents to give you the ability to specially assess the owner for that cost. But again, that will require an amendment. So take a look at your governing documents and discuss internally and with legal counsel.
Yeah.
All right, so first misconception: a foreclosing lender is required to pay 1% of the original mortgage debt or 12 months of delinquent assessments. After all, this is what the statute provides, right? So is that true or false? Well, just because the statute says that, that's not necessarily what is happening. So you need to check your governing documents. Typically, this would be your declaration. Look in the assessment language, in the assessment section. Look for language about a mortgagee's liability for assessments that accrued prior to them taking title for foreclosure. okay? Because you might have language that might give these mortgagees way more protection than the statute provides. It might actually say that these lenders that foreclose don't owe anything to the association. And unfortunately, many lenders over the years have been very successful in using those, those provisions in in the declaration to basically get away with not paying, past due assessments. Okay, so check your language, and if you have that language that basically protects mortgagees, then you want to amend it out, and at a minimum, insert in your amendment the safe harbor language, which is here. Okay, and this would apply to first mortgagees. Okay. All new owners must go through the screening process in your community. Is that true or false? Well, false. I mean, many communities require new purchasers or even tenants to go through their approval process before they occupy a unit. That might not be true for your community. Okay, that is something that's going to be very specific to your community in the governing documents. Okay, so you want to check your governing documents to see if you have language authorizing you to screen purchasers. You might want to screen, tenants or possibly guests or additional occupants. So check to see if you have that language in your documents, and if not, that would require an amendment. If you do have language in your documents that authorize you to screen purchasers and tenants and other types of occupants, then you might have exceptions to those to that approval requirement. One exception that's very common is an exception for mortgagees. So while the lender can foreclose and take title and typically not go through the approval process, if that lender was to later sell the unit or lease the unit, okay, you might have language that says that buyer or tenant from the mortgagee is not required to go through the approval process. Well, you might want to amend that. Why would that, purchaser or tenant have any exemptions? So that might require an amendment. And then, check your documents. There could be also exceptions for spouses or adult children or parents or other types of family members that you might not necessarily want to exempt from the approval process, right? So if that's the case, then you might need an amendment. Okay. Once the law changes, the change is automatically applicable to your community. Is that true or false? Well, that's not necessarily true. Okay, so there are two types of changes that can be done to the statute, right? They're either procedural or they're substantive changes. So substantive changes are changes that affect vested rights. For example, the change to the statute regarding leasing. Okay, that's one example of a substantive change. Procedural changes are more, for example, changes to the voting process that's outlined in the Condominium Act. Okay. So case law came out many years ago that says that if you add Kaufman language, and that's the term that's used, and you might be familiar with it, if you have Kaufman language, which means you add the words as amended from time to time at the end of the reference to Chapter 718 or 720 in your documents, then that means that substantive changes in the statute will apply to your governing documents. Okay, so check your declaration and see if you have those magic words as amended from time to time at the end of Chapter 718 or 720. And if so, every year that the statute changes on procedural or substantive rights, the law will automatically apply to your condominium in your community. Okay. Now, if you don't have those magic words, and that might be if your documents are, older, then the association could make a constitutional argument that substantive changes in the statute, okay, that took effect after the, declaration was recorded in the public record, those changes would not apply to your community. So if you are a community whose declaration was recorded in 1975 and you want to amend your lease restrictions to prohibit leasing, okay, you can potentially make a constitutional argument that this change in the statute that took effect in 2004 does not apply to your community. What does that mean? It means that if you presented this amendment to prohibit leasing and the membership approved it, but whatever percentage is required in your document, well, then it would apply to everyone. Okay. Now, there is unfortunately no precedent case law on this application as I've just described, and so if you were to make that legal argument, it's still unclear how the court would rule because we don't have any biting case law right now on this topic. So what happens is associations don't want to be the test case, so they don't want to spend money, in making these constitutional arguments. So more often than not, associations tend to just add this Kaufman language in their documents and just go with, the changes that are made to the statute from year to year. Okay. The board must obtain a vote of the owners before making any material alterations. Okay. Well, this is one of those where actually kind of depends. Okay. So for condominium associations, you might be familiar, the statute says that unless otherwise provided in your declaration, you need a vote of 75% of the owners in order to make an material alteration to the common element. So if you, for example, want to turn your tennis court into a pool, that is a material, or the division would consider that a material alteration, and so you will need to get the membership approval. Okay. If your documents are silent, the statute says 75%. So you have to check your documents, right, to see what percentage of vote it requires on material alterations. Now, you might have something that says, for material alterations, you require a vote of a majority of the owners. So it could be a percentage threshold that's a little bit less than what the statute provides. In that event, your documents will control. You might have actually a dollar threshold amount. So the board can spend up to X amount on a material alteration, and that could be based on a percentage of your budget, or it might have an actual lump sum amount that's already included in your declaration. So check. And if you have that threshold amount, see what the percentage of membership approval you need to get if you exceed that threshold. Okay. For homeowner associations, there is no, the statute doesn't really address material alteration. So it's going to be something that is very document specific for your homeowner association if you're governed under 720. What you will find, though, more often with HOAs is that you might have a limitation on expenditures, and that could even be in your bylaws. So the association cannot expend more than $200,000 on any given year without membership approval. So if you are going to spend, $200,000 to convert your tennis court to a pool, you might need membership approval on that provision. If it's only going to cost $100,000, you might not need membership approval. Okay, so that's kind of the distinction with HOAs. And then let's say it is a material alteration that you're undertaking. Well, there's also an exception under the law for necessary maintenance. So if the work that you're doing is a necessary maintenance obligation of the association to preserve the common elements or the common areas in the community, and as part of that work, an alteration will need to be made, well, that work might actually fall under this exception. and you might be in a position where you might not need to get a vote of the membership. Okay. These, material alteration scenarios can be tricky. So my best advice is to, seek the advice of your legal counsel, speak with your attorney to see if an exception to the material alteration requirement applies in your case. Okay. And just one more thing on material alterations. If, let's say, you do have already a percentage set forth in your documents for material alterations, you might want to lower it. Okay. Depending on what is it that you're looking to do. So that might require an amendment. All right. Delinquent assessments accrue interest at the rate of 18% and $25 late fee applies. Is that true or false? Well, that is false. So that is what the statute provides, both the condo and the HOA statute. But for late fees, the statute says that the authority to charge late fees has to be set forth in your declaration or bylaws. Okay, that's what both statutes say. So just because the statute authorizes associations to collect a late fee doesn't mean you can't, unless you have specific authority in your documents, your declaration or your bylaws. So check. And the maximum that you can collect is, $25 or 5% of each delinquent assessment. Okay. So if you, let's say, don't have the specific authority, and you wanted to amend your documents to give you the authority to collect late fees on delinquent assessments, the way that we would recommend you to draft the amendment is to say, the association or the board is authorized to collect late fees up to the maximum amount provided by law as amended from time to time. So what this language does is that if the statute were to change and now allow you to recover, $30 or, whatever it might be, then the language in your governing documents now basically automatically will apply the new fee that's in the statute without having to amend your declaration or your bylaws each time. Okay. Now with interest can be charged at the rate provided in the declaration. That's what the statutes say, HOA and, that was for the condominium statute. So with condominiums, interest has to be charged at the rate provided in your declaration. With HOAs, interest has to be charged at the rate provided in your declaration or your bylaws. Now, if your documents are silent, then the rate that applies would be 18%. But many of the older communities have, specific percentage already set forth in the documents, which is way less than what the statute currently provides. So you might be limiting yourself as to how much you can charge. So you might want to take a look at that provision and amend it if necessary. If a pipe in a wall only provides service to one unit, that unit owner is responsible for maintenance. Is that true or false? Well, that depends. So maintenance obligations are set forth specifically in the declaration of the community. Okay. So your declaration of condominium, for example, will describe the boundaries of the unit and then identify who's responsible for what. With HOAs, it's a little bit easier if you just have single family homes. Typically, the owner's responsible for maintenance of the lot. But if you are a townhouse community, okay, where you share walls, depends, you got to look, are you governed under 718 or 720? There are many townhome communities that are actually governed under Chapter 720 of the Florida statute. And so you'd have to look at your documents to see how they define the boundaries of the unit or the townhome. Okay. And then, check out and see what the maintenance responsibilities are. Okay. do these maintenance responsibilities that are set forth in your declaration, do they conform with how you currently maintain, the condominium or the community? And if not, you may want to amend. Okay. It's possible that your documents say that if a pipe services a particular unit, but it's in the common elements, it's the responsibility of the owner. But I've seen it also written so that it becomes an association responsibility. So take a look at your maintenance obligation, see if they conform with how you currently operate, or if you even want to shift maintenance responsibilities. If the association has been maintaining windows, okay, to the units at a condominium, and you want to shift that obligation to the owners, I mean, you could with an amendment, or vice versa. If owners are responsible for maintaining windows, but owners have been very lax on that, and the association wants to take over that responsibility, then you'll need to amend your governing documents. For condominiums specifically, check to see if you have incidental damage language. That is a clause that would say that if the association has to, maintain a common element, let's say a common element pipe behind a perimeter wall, and you have to break through the drywall, if let's say the owner has a backsplash against that wall and you have to break through the backsplash to get to that pipe, well, with incidental damage language, the association would be on the hook for replacing the backsplash. So it could potentially expose the association to significant damage awards. So you might want to consider amending that language out. Check to see if you have self-help language in your governing documents. Recent case law has come out that says, and by the way, self-help means if, let's say, an owner fails to undertake their maintenance obligations, right? The self-help language would give the association the authority to say, enter the unit to, do whatever the owner was required to do and then charge the owner for the expense. Well, case law has come out that now says that if you have that self-help remedy, then the association is now obligated to exercise it, even if it's drafted in a way that gives the association the option but not the obligation. If that language is in the documents, then you have to exercise self-help, or at least try, before the association can file a legal action against the owner to force the owner to do what they're supposed to do. In our opinion, self-help is not always in the best interest of the association. It can certainly expose the association to, unnecessary liability. There's also the potential altercations with the owner if the owner is there. So it's just not a good scenario all around. It really should be applied on a case-by-case basis. So more often than not, we would recommend that the association, file legal action in court to force the owner to do, the repairs or the maintenance. Okay, but if you have that language, you might be limited in your remedy to seek recourse in court.
And
Okay,
I've
so
seen this slide. I've seen this slide a million times, but every time I see it, I'm like, oh my God, there's so many things that can go wrong on either side. Like,
yeah,
especially like if it's a pipe serving one unit, like the slide says, but let's say the owner's responsible to fix it, hypothetically. But the only way to get to that pipe is to go through a wall that is outside the unit, which is association property. And then the owner's responsible. And what if they don't, after the pipe is fixed and then they put everything back together, what if it doesn't look right? I mean, it's, oh my, so many things can go wrong. It's like a nightmare.
so what have we learned? I think we're out of time, but this is basically a summary of everything we've learned. And on the next slide, a healthcare alert. Owning a home in an HOA may be hazardous to your health. So, on that note, this concludes the presentation.
Kirsten, I'm going to turn it back to you and let's go through some questions together. And the first one I'll take, will you be sending out a copy? I just went over that. I'll go over it again towards the end so we can skip that one. Kirsten, I'll leave it up to you to take the ones that are pertinent to the topic here.
Sure. Question from Betty. Is it 5% of the payment, or can the max be $25 regardless of the payment amount? So the statute says it has to be the lesser of either $25 or 5% of the delinquent assessment account. Okay, so the lesser of.
Okay.
Let's see, a question from Denise. Our DRC completed their work 4 years ago. Should we start over? Well, I don't know if you might need to start over, but I'd have to look to see what the changes were. So there's at least a key a few amendments, several amendments in the in your documents that I would be looking for to see if those were updated and how they were updated, and if they might need additional changes.
Okay.
Okay, another question. Do you have an idea of the cost of updating documents or docs are 50 years old? I think this is Dennis Martin. I mean, Dennis, I encourage you to, contact me, shoot me an email after this webinar. We can certainly discuss. I can tell you I've done this plenty in the course of my 14-year career on this, that there's definitely an efficient and more effective way of doing it. And I'm happy to discuss the process that I would recommend, and also not only to streamline the process, but to be more cost effective for the association.
I wasn't joking when I said Kerstin Henze is a walking encyclopedia. So give her a shot. You will not be sorry.
And I would not recommend the board to take a stab at amending the documents and then having legal counsel or for us to review. That typically complicates the process, because then we're trying to figure out what was the intent, right? And amendment drafting is an art form. So I definitely recommend legal counsel to draft amendments.
From my days on the field in management, anytime we tried to do in the past, especially in my my inexperienced years, anytime we tried to do more for less, it ends up being more of a mess. So definitely get it done the first time.
Oh my God. I feel bad for those associations that, have that sort of mindset and ends up being way more costly.
Same thing with your assessment. Same thing with trying to do more for less. It ends up costing you more in the long run.
Yeah. All right, question for Karen. For an HOA, if an amendment was passed regarding leasing prior to 2021, does that apply to all owners or only those who voted for it? So if you were one of the lucky associations that happened to sneak in a lease amendment before the statute took effect in 2021, then it should apply to all homeowners, as long as the amendment was properly approved by whatever percentage was required. Okay. We were certainly, trying to encourage our clients to sneak those amendments in, or, get with proper approval, but before the statute changed.
Yeah.
Let's see. Let's see. What's your guesstimate as to how many associations have a resale capital contribution? Well, I'm not sure if you're well, I don't know. I don't have a guesstimate, but I can tell you that with condominium associations, the division has interpreted the statute as not allowing capital contributions in their documents. For HOAs, they can still charge capital contributions.
Okay. And folks, I'm just going to mention ahead of time, there is absolutely no way we're going to get to all of these questions. There are so many of them in here. So we'll get to some of the ones that are a bit more of a hot button topic and more closely related to what was discussed today. So in no way does it mean that we don't think your question is a good one. In no way does it mean that we don't want to hear from you. It just means that we just simply aren't going to get to all of them because there are so many here in a limited amount of time.
Let's see, a question from Gloria. Is an amendment to reduce the percentage required by owners on voting a material change? I mean, if you're just trying to reduce the voting percentage needed to amend, the documents, it would not be considered a material change, not the way it's defined under the statute, either, HOA or condo. So but for that amendment, you would still need to get the approval of the membership in the original language, or in the original, provision or whatever currently applies. So if you currently need 75% approval to amend the declaration and you want to reduce that voting percentage to a majority, you still need the approval of 75% for that amendment.
Yeah. And folks too, while Kirsten's looking through some of the other questions in this long list here, this evening at 5 o'clock, we have our Ask the Experts. Alan Schwartzide will be on that call this evening, and Kirsten will be back next Tuesday on Ask the Experts, in which you can ask maybe questions that didn't get addressed today on just about any topic. So feel free to check out kbrlegal.com, go to our calendar. If you subscribe to our emails on events coming up, we had one that went out about 20 minutes ago about tonight's TV show, it's hard to say, Ask the Experts. I got to slow down. Check that out as well, because it's another opportunity to, pick our brains.
Mm-hmm. See, question from Sandra. Is it possible or advisable to receive written approval of amendments completely through our e-voting portal? I presume e-voting portal is a platform where owners can vote electronically, and presuming that the board has instituted an e-voting, has authorized e-voting and did so through proper resolution and all that. So if yes, and you have an e-voting platform that you use, yes, you can present the amendments for owners to vote. Only those owners who have consented to vote electronically would be allowed to do that. Everyone else would just have to, vote traditionally.
And Kirsten, she followed up a couple of things down after a meeting to discuss them. Did you see that?
After meeting
I guess that's the second. I guess that's finishing that first question that didn't get typed in originally before she hit send.
Oh, yes.
Okay.
Okay.
Do a couple of more. I know everybody's busy.
Oh man. Can a 720 townhome HOA cap rentals via amending language in its deck? It can cap it can do an amendment to cap rentals, but again, you're now going to be subject to that lease restriction in 720.
Okay.
Okay, so Liliana, could you elaborate on rules and regulations? Can they be used as tools to avoiding making changes to the condo document? So
They supplement the condo docs,
they
right?
should supplement. They cannot, however, conflict with
Right.
your declaration of condominium or covenant. So if an owner were to legally challenge the enforcement of a rule, that is one of the elements that a court looks to see whether a rule is enforceable. Does it conflict with the declaration? And so if the declaration, for example, is silent on a restriction, for example, if the declaration doesn't prohibit pets and you're trying to get around amending your deck by adopting a rule that says pets are prohibited, well, the presumption under the law is that pets are not restricted under the declaration. And so by adopting a rule that basically prohibits pets, now you're in conflict with your declaration. Okay, so that rule might be subject to legal challenge. So you want to get together with legal counsel when you when you draft rules. Make sure they're not in conflict with your documents.
Yeah. Another example would be something like, if you have certain stipulations about the community pool, but then you have a sign at the side, right? Or that mimics what's in your, like no diving. You don't need to have no diving in your pool, as part of the association documents.
Correct. I mean, typically when it comes to your common elements, and provided you have authority in your documents to even adopt rules, right? You have to have something in your documents that says the board can adopt rules.
Yeah.
But typically, rules regarding use of common elements like your pool and, your catwalks, that you can adopt as a rule as opposed to an amendment to your declaration.
Yeah.
Okay. I think on that note, are we good?
Yeah, I think we're good. Kirsten, before you head out and get to your next meeting, which I know is coming up in about 10 minutes, give everybody on the line and folks who didn't get their questions answered, I will send a Q&A report to Kirsten, but also we have the evaluation that you can put some comments and questions on there as well. So I'll go over that in just a moment, but before you go to your next meeting, please let everybody one more time know the best way to reach you.
Sure. I mean, you can certainly reach me, by email, which is right here on the on whatever this is called. Not very
Right on the
electronically
screen.
savvy
And-
on the
and-
screen. Or you can call the main office, 954-928-0680. And with the click of a button, your call will be routed to my office here in Tampa.
Sounds great. So you don't have to memorize a local phone number. The main number will get you any one of our locations: Tampa, Orlando, Palm Beach, Pompano, everywhere we work, everywhere we do some business. So Kirsten, thanks so much. Wonderful job. You're such a television pro at this now. This is fantastic. It's great doing this with
Thanks,
you.
Jeff. And thank you everyone for spending your time with us. We appreciate it.